I was only trying to keep things running smoothly, but now I'm the scapegoat for everything wrong. I don't understand how things escalated this far. I really don't. For years, our HOA ran just fine. Not perfectly, nothing ever is, but we handled things reasonably. We kept the common areas maintained, made sure things looked presentable, and handled small issues before they became big ones. That's what an HOA is supposed to do. I've always believed that. So when I joined the board, I took it seriously. One of the ongoing issues we had was parking. Not for residents, that was fine, but for HOA-related vehicles. Maintenance trucks, landscaping equipment, deliveries for the clubhouse. We had a small cement slab next to the clubhouse where we parked them, but it wasn't enough. That's where the vacant house came in. It had been empty for years. No occupants, no activity, nothing. Just sitting there with a large driveway that could easily fit 3 cars. The slab we used connected directly to that driveway, and over time, it just made sense to use it as overflow parking. No one complained. No one even noticed, really. It was practical, efficient, a solution. Then the couple moved in. At first, I thought it would be fine. They seemed quiet, kept to themselves, only had 1 car, which honestly made the situation even easier. There was more than enough room for everyone. So when they came to the board asking us to stop parking there, I was confused. We'd prefer if you didn't use our driveway, they said. I tried to explain. It's only for HOA purposes, I told them. And you're not using that portion anyway. It's just sitting empty. They didn't see it that way. It's our property, the husband said. Of course it was their property. But we weren't taking anything from them. We were using space that would otherwise go unused for the benefit of the entire community. That's how I saw it. That's how it was. Still, they insisted. We discussed it at the board meeting. Everyone agreed that stopping would create more problems than it solved. We had nowhere else to put the vehicles without disrupting other areas. So we continued. Then they had one of the HOA vehicles towed. No warning, no discussion. Just gone. Do you know how disruptive that is? We had to send someone to retrieve it, pay the towing company, deal with the scheduling delays. It threw everything off. So we did what we were supposed to do. We charged them for the cost. It was their action that caused the problem. They refused to pay. At that point, it stopped being about parking and started being about principle. If residents could just decide not to cooperate with the HOA whenever they felt like it, the whole system would fall apart. So we issued fines, standard process. They refused those too. We warned them, they ignored it. At one point, we even offered a compromise, continued limited use of the space, coordinated scheduling, but they wouldn't budge. It was no parking at all, and nothing less. Eventually, we had to consider alternatives. The only real option was to pour a new slab. It wasn't cheap, and it definitely wasn't in the budget, which meant the cost had to be recovered somehow. It didn't seem fair that the entire community should absorb that expense when it was caused by one household refusing to cooperate. So we billed them. They refused again. At that point, the fines started accruing interest. That's standard policy. The longer it goes unpaid, the more it increases. They still didn't pay. After 3 months, we placed a lien on the property. Again, standard procedure. At least it should have been. They took us to court, and that's where everything shifted. I thought the hearing would be routine. That's the word our attorney used, routine. A disagreement over HOA authority. Some clarification about shared use. Maybe a compromise the judge would encourage so everyone could move on. I wore something conservative, neutral, professional. I wanted to look like what I was, a board member trying to do what was best for the community. The couple sat across from us, calm in a way I didn't quite understand at the time. Their attorney didn't look calm. He looked prepared. That should have been my first real warning. Our attorney opened by explaining the situation the way we had always framed it. A long-standing practice, a reasonable use of adjacent space, and a sudden disruption caused by new homeowners, unwilling to cooperate with community needs. It sounded right when he said it. It had always sounded right. Then their attorney stood up. He didn't raise his voice, didn't argue emotion. He just walked to the evidence table and picked up a set of documents. "Your Honor," he said, "this case is not about cooperation. It's about unauthorized use of private property." He held up a survey map. Clear lines, property boundaries. The driveway, their driveway, outlined in thick black ink. Then he placed it down and slid forward a series of photos. Choe vehicles parked fully within that boundary. Multiple dates, multiple times. Then came the emails. That's when things started to feel different. The first one was mine. I recognized it immediately. They're only using one car. There's no reason we can't continue using the rest of the driveway. At the time, it felt like common sense. In the courtroom, it sounded like something else. Their attorney didn't comment on it. He just let it sit there before moving to the next piece. Meeting notes, minutes from board discussions. More of my language, community benefit, unused space, unnecessary resistance. Then came the part I wasn't expecting. Internal messages. Not official minutes, side communications. Emails between board members. A few forwarded threads. Notes that had never been meant for anything beyond discussion. And my name kept appearing, not alone, but often. Suggestions, recommendations, pushing to continue using the driveway, even after the couple objected with the escalation, and fines and interest in lien. The attorney paused before presenting the next document. This, he said, is the notice authorizing removal of the HOA vehicle from the property. He turned a page, and this is the invoice sent to the homeowners for retrieving that same vehicle. Then another page, and this is the billing notice charging them for a new concrete slab, installed after they enforced their property rights. He let that sink in, then finally he said, retaliation. I felt something drop in my stomach. Our attorney objected, argued interpretation, claimed it was all within HOA enforcement policy. The judge wasn't convinced. He leaned forward, flipping through the documents again. Did the HOA have permission to use the driveway? He asked. Our attorney hesitated. Not explicitly, Your Honor, but did they continue using it after being asked to stop? Yes. And did they then impose financial penalties when the homeowners enforced their rights? Silence. That silence felt louder than anything that had been said all day. The ruling came shortly after. The lien was invalid. The fines were dismissed. The HOA had overstepped. But the hearing didn't end there, because once the decision was made, the focus shifted. Not just to the HOA as a whole, but to how those decisions had been made. The judge didn't say my name. He didn't have to. The couple's attorney already had. After the hearing, the board called an emergency meeting. At first, it was about damage control, legal exposure, community perception, next steps. But it didn't stay that way. Someone brought up the emails. Someone else mentioned the escalation, the insistence, the push to continue using the driveway, to pursue fines, to authorize the lien. One by one, the conversation turned, not outward, inward, and eventually, toward me. It wasn't loud, no one raised their voice, but the tone shifted. Careful, measured distancing. I think we need to reevaluate how these decisions were made. We relied heavily on certain recommendations. Perhaps there was overreach. I sat there listening as the same people who had agreed with me, who had nodded in meetings, who had supported every step, began stepping back, not denying it, just separating themselves from it. By the end of the meeting, the decision had already been made. They didn't call it removal. They called it a transition, a necessary change to restore trust. But the result was the same. I was no longer on the board, and just like that, I went from someone trying to keep things running smoothly to the person they blamed for everything going wrong.